And the judge overseeing the long-running racketeering trial against rapper Young Thug has been removed from the case. This comes after two defendants sought Judge Earl Glanville's recusal, citing a meeting with the judge and prosecutors, as well as a state witness.
When Judge came out, and Brian Steele, the attorney for Young Thug there, said, hey, I found out there was a meeting and I wasn't a part of this, and you didn't even tell us what occurred there.
One of hip-hop's biggest names sits in a courtroom, fighting charges that could change everything. But what happens next isn't about the defendant at all. It's about what occurred when nobody was watching. Jeffrey Williams, better known by his stage name, Young Thug, found himself at the center of a massive legal battle in Georgia. Back in May 2022, prosecutors in Fulton County came after him hard, filing an indictment that accused him of running something they called a criminal enterprise. They claimed his record label wasn't just about making music. They said it was a front for illegal activities involving weapons, substances, and organized criminal behavior. The charges were serious enough to land him in a trial that would stretch on for months under Georgia's tough gang laws. By early June 2024, the trial was already deep into its proceedings when things took an unexpected turn that would expose cracks in the system itself. But here's where it gets interesting. When silence becomes a problem. On a Friday morning in June, Judge Earl Glanville, the man controlling everything in that courtroom, faced a challenge. A witness who was supposed to provide testimony decided he wanted nothing to do with it. Despite being offered full immunity, meaning he couldn't be prosecuted for anything he admitted to, this witness invoked his Fifth Amendment right and refused to speak. Now, most people know the Fifth Amendment protects you from self-incrimination. But here's the catch. When you're given immunity, that protection technically disappears because you can't incriminate yourself if you're already protected from prosecution. The judge saw this refusal as defiance. His response? Lock him up until Monday and see if a weekend in jail changes his mind about cooperating. What happened next would spiral into something nobody expected. Monday morning arrived, and the witness apparently had a change of heart. But the way that change happened is where our story really begins. Judge Glanville didn't bring everyone back into open court to sort this out. Instead, he held a private meeting in his chambers, his personal office behind the courtroom. Present for this closed-door discussion were the judge himself, the prosecutor named Adrian Love, the reluctant witness, and the witness's legal representative. They talked, a court reporter documented every word, and by the end of it, the witness agreed to testify. Sounds reasonable, right? Except there's one massive problem. The defense attorneys, the lawyers fighting for Jeffrey Williams and his co-defendants, weren't invited. They weren't even told the meeting was happening. This type of private conversation has a specific legal name, an ex parte communication. In plain language, it means one side talks to the judge while keeping the other side completely in the dark. Georgia's judicial rules are crystal clear about this. Judges cannot initiate, allow, or consider these types of one-sided conversations when a case is actively being tried. There are rare exceptions, but they're extremely narrow. Why does this rule exist? Because justice only works when everyone gets a fair shot. When secret meetings happen, trust evaporates. Decisions get questioned. The entire foundation of a fair trial crumbles. Brian Steele, one of the defense attorneys representing Williams, somehow learned about this private meeting. We don't know exactly how the information reached him. That detail becomes crucial later, but once he knew, he had a professional obligation to address it. Standing in open court, Steele confronted the judge directly. He carefully laid out what he'd been told.
Supposedly, in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on.
That a meeting took place in chambers involving the judge, the prosecutor, the witness, and the witness's lawyer. He explained that the defense team had no idea this was happening while they waited outside the courtroom. Steele made it clear this wasn't just improper, it potentially violated his client's constitutional rights. But Judge Glanville's reaction wasn't what anyone expected. Instead of addressing the substance of Steele's concern, the judge fixated on something else entirely. How did you find out? This question immediately shifted the entire dynamic in the courtroom. Steele had raised a legitimate issue about potential judicial misconduct, but suddenly he was the one being interrogated. The judge demanded to know Steele's source, the person who leaked information about the private meeting. Steele refused to answer. He cited attorney-client privilege, explaining that the information came through his professional relationship with a client and that revealing his source would violate sacred ethical obligations. Lawyers are bound by strict confidentiality rules. They cannot disclose information obtained through representing clients without permission, regardless of how important that information might be. The judge wasn't having it. Judge Glanville gave Steele 5 minutes to think it over. The unspoken threat was clear: reveal your source or face consequences. When court reconvened after the break, Steele maintained his position. He argued that Georgia's professional conduct rules protected not just direct communications from clients, but all information gained through the attorney-client relationship, regardless of where it originated. The judge saw it differently. He argued he wasn't asking about the content of what was said in chambers, only how Steele obtained that information. In the judge's view, this didn't implicate attorney-client privilege at all. Here's where the situation escalated beyond anyone's expectations. Judge Glanville held Brian Steele in contempt of court. This wasn't just a verbal reprimand. It meant Steele could be jailed until he complied with the judge's order to reveal his source. The deadline was set for 5 p.m. that same day. Think about the irony here for a moment. Steele raised concerns about improper secret communications affecting his client's right to a fair trial. The judge's response? Threatened the defense attorney with jail time for not revealing information he believed was protected by professional ethics rules. Steele stood firm. He explained to the judge that this wasn't about being difficult or defiant. It was about understanding his obligations under the rules governing attorney conduct. Rule 1.6 of Georgia's Professional Conduct Rules explicitly requires lawyers to keep confidential all information gained in the professional relationship with a client, whatever its source. While there's an exception allowing disclosure when required by court order, Steele clearly believed this situation didn't qualify. The judge interpreted the rules differently, and he had the power to enforce his interpretation. The mistrial motion, raising the stakes. Steele didn't just sit back after being held in contempt. He immediately moved for a mistrial, arguing that the judge's ex parte meeting with the witness was so fundamentally unfair that the entire trial needed to be scrapped and started over from scratch. A mistrial is essentially a legal reset button. It acknowledges that something went so wrong that continuing the current trial would be impossible or unjust. If granted, the case would have to be retried before a completely new jury, assuming double jeopardy rules didn't prevent it. Steele cited a 2016 Georgia Supreme Court case called Scudder v. State to support his argument. That case established that criminal defendants have a constitutional right to be present at all critical stages of their trials. The courts have consistently held that interactions between judges and witnesses qualify as critical stages because they can directly impact the evidence and testimony that juries hear. Here's the key distinction that made Steele's argument so strong. In the Scudder case, the defendant lost his argument about improper ex parte communication because the judge had announced in open court his intention to speak privately with a witness, and neither the defendant nor his lawyer objected. By staying silent, they essentially gave permission. Lawyers call this waiving a right. But in Williams's case, something fundamentally different happened. The judge held his private meeting completely in secret. The defense wasn't informed, wasn't present, and therefore had no opportunity to object or waive anything. They were deliberately excluded from a critical stage of the trial without their knowledge. This distinction matters enormously. It's the difference between someone choosing not to exercise their rights and someone being denied the opportunity to exercise those rights in the first place. Judge Glanville attempted to defend his actions by explaining that the state requested the ex parte meeting and that he believed it was appropriate under the circumstances. He compared it to other ex parte communications that happen routinely in legal proceedings. But this comparison doesn't quite hold up under scrutiny. Yes, judges sometimes have private conversations with individual attorneys about scheduling matters, procedural questions, or administrative issues that don't affect the substance of a case. Those are generally considered acceptable because they don't involve witnesses, evidence, or anything that directly impacts the trial's outcome. Meeting privately with a witness who's been sworn in and is refusing to testify, that's something else entirely. That goes directly to the heart of what evidence the jury will hear. When a judge applies pressure to a witness in private, convincing them to reverse their decision not to testify, that's not a minor procedural matter. It's a substantive intervention that affects the entire case. The prosecutor, Adrian Love, jumped in to defend the state's position, arguing that Steele was trying to misrepresent what actually happened in chambers. She suggested that Steele's real goal wasn't to address a legitimate concern, but to create a record that could help on appeal if Williams was convicted. But this argument misses the fundamental point. The aftermath, consequences, and questions. Brian Steele found himself in a position no lawyer wants to be in, held in contempt and facing potential jail time for doing what he believed was his job. The contempt order meant he could be taken into custody immediately unless he complied with the judge's demand. The irony is inescapable. Steele raised legitimate concerns about whether his client was receiving a fair trial. Instead of addressing those concerns on their merits, the judge focused on punishing Steele for having information he supposedly shouldn't have possessed. This dynamic raises uncomfortable questions. If lawyers can be threatened with jail for raising concerns about judicial conduct, what does that do to their ability to effectively represent their clients? Does it create a chilling effect where attorneys become afraid to challenge problematic behavior by judges? And if that happens, who protects defendants' rights? The prosecutor's perspective deserves consideration too. From the state's viewpoint, they requested an appropriate ex parte meeting to address a witness who was refusing to testify despite immunity. They might argue that such meetings are sometimes necessary to resolve logistical issues without turning every minor problem into a circus in open court. They might also argue that recording the meeting and making the transcript available addresses transparency concerns. But even accepting those arguments, questions remain. Why wasn't the defense at least informed that the meeting was taking place? Could the same objective have been achieved in open court, even if the jury wasn't present? And does the fact that the witness changed his mind after meeting privately with the judge create an appearance of improper pressure, regardless of the judge's intentions? Georgia's Code of Judicial Conduct is unambiguous about ex parte communications. Rule 2.9 prohibits judges from initiating, permitting, or considering ex parte communications about pending matters except in very specific circumstances. None of those exceptions clearly apply to a judge meeting privately with a sworn witness to convince them to testify. Meanwhile, Georgia's rules of professional conduct impose strict confidentiality obligations on attorneys. Rule 1.6 requires lawyers to maintain confidence all information gained in the professional relationship with a client, regardless of its source. The only exception relevant here is when a court orders disclosure, but Steele clearly believed this situation didn't qualify for that exception. So we have competing ethical obligations. The judge believes his authority to order disclosure overrides attorney-client privilege. The attorney believes his ethical obligation to protect client confidentiality prevents him from complying with that order. Who's right? That's for appellate courts to decide. When judges hold attorneys in contempt, those orders can be appealed. Steele's contempt citation could be challenged in higher courts, where appellate judges would examine whether Judge Glanville was correct in his interpretation of attorney-client privilege and whether the contempt order was appropriate. Similarly, if Williams is convicted, his lawyers will almost certainly appeal based on the ex parte communication issue. Appellate courts would have to decide whether that private meeting violated Williams's constitutional right to be present at critical stages of his trial, and if so, whether that violation requires reversal of any conviction. The Scudder case that Steele cited provides a roadmap. It says defendants have the right to be present at critical stages, and that meeting with witnesses qualifies as a critical stage. It also says that right can be waived, but only if the defendant knows about the meeting and chooses not to attend or object. Here, there was no waiver because there was no knowledge. The meeting happened in secret. That factual distinction could be enough for an appellate court to find reversible error. This situation highlights broader issues in our criminal justice system that extend far beyond one courtroom in Georgia. First, it raises questions about judicial accountability. Judges wield enormous power in courtrooms. They make rulings on evidence, control procedure, and can hold people in contempt. But what meaningful checks exist on that power during trial? If a judge acts improperly, defense attorneys can object and create a record for appeal, but if the judge punishes them for doing so, does that effectively silence criticism? Second, it demonstrates the complexity of attorney ethics. Lawyers face multiple obligations that sometimes conflict: duties to clients, duties to the court, duties to the profession. When those obligations collide, there's often no clear right answer. Steele genuinely believed he couldn't reveal his source without violating professional ethics. Judge Glanville genuinely believed Steele was hiding behind privilege inappropriately. Both could sincerely believe they were right. Third, it underscores how critical transparency is to public confidence in the justice system. When meetings happen behind closed doors, when one side is excluded, when information is kept secret, it breeds suspicion. Even if nothing improper occurred in Judge Glanville's chambers, the secrecy itself damages the appearance of fairness that's essential for legitimacy. So what really happened here? Did Judge Glanville commit judicial misconduct by meeting privately with a witness? Did Brian Steele violate court orders by refusing to reveal his source? Or is this simply a complicated situation where reasonable people disagree about the proper application of competing ethical rules? The answer probably depends on your perspective. From the defense standpoint, a judge secretly met with a witness and convinced him to testify without giving the defense any opportunity to be present or object. That looks like a violation of fundamental fairness and constitutional rights. When the defense attorney tried to address this problem, he was punished for it. That looks like retaliation for doing his job. From the prosecution standpoint, they properly requested a meeting to address a witness issue, it was recorded for transparency, and a defense attorney somehow obtained information he had no business possessing and then refused to explain how he got it. That looks like someone benefiting from an improper leak and then hiding behind privilege to avoid accountability. From the judge's standpoint, he held a routine ex parte meeting at the state's request, properly recorded it.
That reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th.
And then discovered that confidential information from that meeting had leaked. When he tried to investigate the breach, a defense attorney obstructed that investigation and refused to comply with court orders. That looks like contempt of court. All of these perspectives contain elements of truth, yet they lead to completely different conclusions about who acted appropriately. This entire controversy teaches several important lessons about how our justice system works, and sometimes doesn't work. Transparency matters more than efficiency. Even if meeting privately with the witness was more convenient or efficient, The lack of transparency created problems that far exceeded whatever time was saved. Open proceedings, even when inconvenient, protect everyone involved. Ethical obligations can conflict in ways that create impossible situations. Steele faced an impossible choice between complying with a court order and violating what he believed were ethical obligations to his client. The system needs better mechanisms for resolving these conflicts before they escalate. Judicial authority has limits, even if those limits aren't always clear. Judge Glanville had broad power to control his courtroom, but that power isn't unlimited. When judges act in ways that appear to benefit one side or exclude the other from critical proceedings, their authority becomes questionable. Defense attorneys play a crucial checking function in the system. If Steele hadn't raised these concerns, the ex parte meeting might never have become public. Defense advocacy, even when uncomfortable for judges and prosecutors, serves an essential purpose in keeping the system honest. This situation didn't happen in a vacuum. The trial of young Thug and his co-defendants has been one of the longest and most complex criminal prosecutions in Georgia history. By the time this controversy erupted, the trial had already been going on for months, with testimony from dozens of witnesses and thousands of pages of evidence. In that context, you can understand why everyone involved was under tremendous pressure. The judge was trying to manage an unwieldy case that threatened to stretch on indefinitely. The prosecutors were trying to prove their case despite reluctant witnesses. The defense attorneys were trying to protect their clients' rights in a media circus atmosphere. None of that excuses what happened, but it helps explain how a relatively straightforward situation, a witness refusing to testify, spiraled into a constitutional controversy that threatened to derail the entire trial. Where do we go from here? As of when this controversy erupted, several questions remained unanswered. Would Steele be jailed for contempt? Would the motion for mistrial be granted? Would appellate courts ultimately conclude that the ex parte meeting violated constitutional rights? But the bigger question transcends this specific case. How do we maintain fairness in our criminal justice system when the people responsible for ensuring that fairness sometimes disagree about what fairness requires? There's no easy answer. The system depends on good faith efforts by judges, prosecutors, and defense attorneys to follow the rules and respect each other's roles. When those good faith efforts break down, when trust evaporates, when competing obligations collide, we're left with situations like this one where everyone claims to be right and nobody's clearly wrong. What we can say with certainty is that transparency would have prevented this entire controversy. If Judge Glanville had either met with the witness in open court or at least informed the defense that a private meeting was taking place and given them the opportunity to attend or object, none of this would have happened. Steele wouldn't have had to find out through back channels. There would have been no secret to keep, no source to protect, no contempt citation to fight. The lesson is simple. Sunlight remains the best disinfectant, even in courtrooms. If you have liked the video, just subscribe the channel to get more insightful content.